Welcome to another edition of Inside Rosenberg and Estis. I'm Dave Lorenzo, and today we have two of the firm's top litigators with us, and we are producing this show for you by popular demand. That's right. Thanks to your outreach, we are back to discuss how litigators can help make transactional leases even better. Now, as a reminder, for those of you who are joining us here at Inside Rosenberg and Estes for the first time, what you're going to hear on the show today is for your entertainment purposes only. That's right, we're three guys just here to entertain you. We are not giving any legal advice, but if you hear something and you have a question, we will provide all kinds of information down in the show notes for you to reach out to either Adam or Alex here on the show, and they can help you with any legal need that you have. So since I've already kind of introduced them, let me bring both of these gentlemen on. We have with us today Alex Estes and Adam Lindenbaum. Alex and Adam, welcome back to the show.
Thanks, Dave.
Thanks, Dave.
All right. Well, it's great to have both of you here. Our topic today is about how litigators can not only be helpful, but can provide a lot of insight into leases at the transactional stage or at the review stage before they're signed. So in preparing for the show, we talked about a lot of the issues that come up that you guys will often catch. So Adam, let me start with you. Why don't you share with us some of the things that you've seen in leases when they're getting ready to be signed, but you've caught them before they go to the client to be signed?
Sure. Well, that I actually have, or that I wish I was there to do.
That's really a good distinction. So let's start there, Adam. What are some of the things that you wish you were able to fix before your clients sign the lease?
Well, look, I've been doing this over 20 years, and my view on leasing as a litigator, I can pull them apart really well. Why couldn't I put them back together? And I think I can, and I have for a lot of my clients in this space. And I wanted to just start out by congratulating Alex on an excellent Law Journal article and round one. I was so jealous that I didn't think of the idea at the outset, that I was really honored that, just talking in the hallway, he invited me to come on round two.
It's always a pleasure to talk with Adam. Adam is one of the best litigators in our firm, and he's brilliant and just always an absolute pleasure to talk to.
Yeah, so just to answer your question and dive in, Dave, we can back up later on, but I had a lease dispute with a client. It was an industrial property where our client was the purchaser. And as part of a unique transaction, they agreed to lease the building back to the seller for a 2-year term. And then after that 2-year term was like at a preferential rent as part of the overall consideration of the sale. And then at the end of the 2 years, they agreed upon a 5-year fair market value renewal option. And there was an increase between year 1 and year 2, both of which were still below market value. Now, at the time, the leaseback made sense for both sides because there was an active environmental cleanup at the property. It would have made it difficult for the landlord or the new owner to rent it to anybody else on the market. But because the seller was familiar with the property, it made sense for them to continue because they knew what to expect and what they would encounter. But at the end of that year 1, the tenant refused to pay the increase coming on year 2, citing its business downturns. And the landlord rightfully didn't want to renegotiate the deal. They made the deal. They paid a lot of money to purchase the place. So they were looking to negotiate an exit. But the problem came in was that the attorney who prepared the lease had the standard sublet and assignment clause, right? Which a lot of times in leases will say the landlord's consent not to be unreasonably withheld. Okay, and this is where the parties failed to see eye to eye about what their rights were, because from the landlord's perspective, you pay what we agreed or get out. But from the tenant's perspective, it was, I have kind of an asset here. I can go to the market, take this below market rent that you promised to me, and I can look to sublet that at a profit. And the language that's in the lease that you prepared allows me to do that. So, had a more restrictive sublet and assignment clause be employed to tailor to the short-term tenancy at issue in this particular transaction, landlord might have been in stronger position to recover its damages in litigation or to end the tenancy sooner. It was a case that we wound up settling, but it was one of those situations that, oh, I wish I had a hand in this lease before we got to where we got.
So, Adam, in that particular case, what was the ultimate resolution, just so that we can close the loop for people? Did the tenant end up subletting? Did they renegotiate? Did all end well in the end? Or did they have to litigate?
We litigated. We litigated in the landlord-tenant courts, and we leveraged a voluntary turnover of possession of the property because the tenant realized that the clock was ticking. They had this 1 year. It became less and less marketable, and its efforts weren't very real to begin with, but it was just an excuse to hold the rent up for a while. So we received possession back in the landlord-tenant case without prejudice to the parties' monetary claims, and then we started a case to recover the money, and we settled that. Due to collectability issues, threatened bankruptcy, the terms of the guarantee, which were limited, and that which was part of the deal. So all things considered, the landlord walked away with a little bit of money and got its space back.
Got his space back. Okay. All right. So, Alex, we're gonna do a beat the past bad actors beat the past bad actors story. Do you have a case study that you want to give us where you wish you intervened in advance?
Tell you the story that made me want to get involved in leasing to begin with.
All right.
The situation I'm going to describe. Luckily, I was on the other side of this one, and I had nothing to do with the lease. I was representing a landlord that retained us to commence litigation against the guarantor for the tenant's failure to pay rent. And what's commonplace in a lot of commercial leases, and this is a commercial context, is that these documents will provide for what's called service of process. For those of you at home that may not know what that means, service of process is the method that a party that's suing in court has to serve the other side with papers. Now, when you see in the movies, you've been served. That's service of process. It's essentially to put the other party on notice that they're being sued, and it gives the court the ability to get what's called jurisdiction over that individual. Now, in leases and contracts, we typically account for this because otherwise you have to hire a process server, you may have to find where the person lives. Sophisticated parties want to make it more streamlined. And the problem is, service of process is a very basic thing for a litigator. We deal with it every day. We know it. Transactional attorneys are aware of the concept, but may not always understand how service of process works or what that means. I had a situation where we were suing the guarantor, and the guarantee provided that the guarantor will have a designated agent for service of process, and that agent was the attorney that prepared the lease for the tenant. So what that means is, instead of me trying to, serve Dave Lorenzo personally with papers, I'm going to serve his agent, Adam Lindenbaum, with papers. And all I have to do is, overnight mail Adam Lindenbaum with papers for Dave Lorenzo. Even though I'm not handing it to Dave Lorenzo, for purposes of court, I have acquired jurisdiction over you, Dave, and I could proceed with my litigation against you. So,
I'll accept the appointment, by the way.
Adam accepts the appointment. There you go. In this situation, the transactional attorney was the designated agent for service of process, but he confused it with just lease notices. Sometimes transactional attorneys, when you send a notice under the lease, it goes to the tenant, goes to the landlord with a copy of their counsel. He didn't realize that that meant that he was accepting service for a lawsuit, and he never passed the information on to the guarantor. So I started a lawsuit, and I sent it to the attorney, and he said, you can't send this to me because I don't represent them. I was only retained to do the lease. But because he agreed to be the irrevocable designated agent for service of process, we were able to commence the lawsuit. We served the attorney, and we ultimately got a judgment against the guarantor for a very large amount of money. And when the guarantor finally learned about it, it was after we got the judgment, and he said, "Well, you didn't serve me. How could you get a judgment against me if I didn't know about it?" It's because the contract provided that the attorney was the person to serve. Now, the attorney in this situation, and this was not an attorney with our firm, thank God, we would never do something like this, should have told the guarantor about it and had a duty to do so. But because of that, we were able to get the judgment, and the guarantor had no viable means to challenge it because the case law in New York is very clear on this issue. When you have a designated agent of service of process that's unequivocally stated in the contract as to what to do, you can serve them that way. Now, that's a situation where if I was representing the tenant in that situation, or if I was a litigator, which I happen to be a litigator and I happen to represent tenants from time to time, I would have explained to my client that this is not something that you should agree to, that you want to make sure that you get the papers yourself, or I would have made sure that there was a mechanism in place to make sure he gets it. This is an example of one of the things that when you have a transactional attorney, they're dealing with litigation aspects, because if a lease ever gets looked at again, for the most part, it's because someone didn't do what they're supposed to do. And the litigator in that context is going to look at it with a different set of eyes than the transactional attorney. And that's why you want to have your litigator involved. You're ultimately going to have to end up paying the cost for it, but you better pay the cost for it when you're doing the lease than have to pay a higher cost when you're litigating down the line.
Alex, that is an unbelievable story. I don't know what to say about that other than if that doesn't scare the hell out of you and want you to have a litigator take a look at your lease, I don't know what will. Adam, what are your thoughts?
I agree with you totally. Oh, and Dave, I thought of an answer to your first question because I made a list of leases that I have been involved in. This is one where I was involved, where we had our client was a commercial landlord, and the tenant was a well-known pharmacy drugstore here in Manhattan. The tenant had a 5-year renewal option after an initial 10-year lease term. And there was a window for the tenant to exercise the renewal option, and they did that. They did that just as a matter of course. They had a department that is probably solely devoted to not letting these renewal options lapse, and exercise the clause. But one area where we were particularly adept in negotiating this clause is that the rent reset on the 5-year renewal option was the greater of the last rent paid under the initial term of the lease plus 10% or the fair market value, right? So the landlord agrees to a floor, but if the lease, if the market for the space goes up, we could go to arbitration over that. Well, the problem with this is this kind of coincided with the COVID-19 downturn in the retail market, and given the decimation of what happened in 2021, 2022, the landlord looked at this and said, wow, our lease is already above market. Landlord was happy to take the 10% bump, avoid litigation, arbitration altogether, over FMV, and just take the free rent increase. And where the litigation services, it was pre-litigation services, came into play was the tenant realized its mistake. The broker realized the mistake and tried to renegotiate with us. But this litigator, with a little bit of research and a couple of well-cited cases, was able to convince the tenant that the case law is clear that when a tenant goes and actually exercises the renewal option under a lease, it's self-operative. We successfully demonstrated to the tenant and the broker, if you want to sue over some kind of declaration or equitable revocation of the exercise of what you've done, it's like putting the toothpaste back in the tube. It's not going to go well for you. You're going to be likely to fail. Just keep doing what you're doing, and we'll talk to you in 5 years. And that's exactly what happened.
So for each of you, I have a question now. If you get a lease on your desk, What are the first 2 or 3 places in the lease where each of you would look to make sure that this specific clause is buttoned down? Let's start with Alex. Give us your first one, and then I'll go to Adam, and then we'll do one more round. Alex, what's the first place you would look if a lease comes across your desk?
Well, if a lease is coming across my desk with no context about that specific deal or the issues, being a litigator, the first thing I look at is the default provision and the notice provision. I look to see if there's a termination option. Because when you're litigating, those are really the first 3 provisions you're going to look at. You want to look at what damages are. Is there an acceleration of damages for the rest of the term? What does the landlord have to do to default the tenant? What does the landlord have to do to recover possession? What are the tenant's remedies? Who gets notices? Those are the most important things, because those are the things that when you go to court, those are probably going to mostly govern how you go to court, not in all situations. But a lot of times, I look at those to make sure that there's methods in place that if I'm representing the landlord, that it's very clear what you have to do and that there's no ambiguity. I had a situation very recently where a client wrote the lease himself and put in a termination option for the tenant. And the termination option was very unclear as to if the tenant had to pay rent or not before the tenant vacates and how much notice they have to give. It made sense if you were speaking in slang in casual conversations. For legal construction, it did not make sense. So as much as a client may want to try and do things themselves, there are a lot of things that people can do very well. Please don't ever write a lease yourself. Always contact an attorney. But those are the 3 provisions that I always look at first when I'm looking at a lease. Adam, I don't know if you look at the same ones or anything different.
Yeah, me too. Default clause is so important because it really frames the kind of cause of action that a landlord is able to commence in order to enforce its rights. But a couple of others that are super important to look at right at the beginning. What contingencies are there? If it's a restaurant lease, do you have a liquor license contingency? Cannabis, do you have a license contingency? Anything else that the parties may agree on the term sheet, those have to be crystal clear because there's brokerage commissions on the line, there's legal fees in getting the lease drafted, and if the parties' expectations with respect to getting those hurdles cleared at the outset of the term of the lease are not crystal clear, there's going to be a lot of negative feelings not too far into consummating the deal with signatures. So that's important. And then the other comes way at the end is the restoration obligations. A lot of times I've seen leases that, will take, say, like a bank lease and transform it to a restaurant lease. It doesn't make sense given the scope of alterations that the tenant is going to be performing under the tenant's work obligations in order to get the space up and running for its use. So is the bank going to remove a vault? Likely not. Is a pizzeria, is the landlord going to want to keep that space as a pizzeria afterwards and keep the ovens and the other fixtures to sell as part of key money? Or is it like an office space where everybody can presume that the chairs and the desks are going to be worn out, and after a 15, 20-year term of the lease, the landlord's going to want the white box down to the shell and core that it leased to the tenant and get it completely emptied out. So speaking with the landlord and evaluating what the long-term plan is at the end is also extremely important because restoration is expensive.
Well, to Adam's point, actually, Adam, you raise a really good point, though, about matching the term sheet, which is something that any lawyer should make sure is done, that the contract matches the term sheet. I don't know if you see this a lot, Adam, but I've had so many litigations over ambiguity and uncertainty as to what the language means. A lot of transactional attorneys, they think they understand what, we know what we're talking about. It's very clear to the parties. But a litigator that wasn't involved may come in and say, I'm not sure what this means. I read it 3 ways. A judge may read it 3 ways. And so I personally had litigations that lasted years and cost clients millions of dollars trying to figure out what that clause actually meant. There are so many litigations and so much money and heartache that could be avoided. Just having that second set of eyes to make sure okay, we all agree this is what it says. Because it's amazing when you get 5 people in a room, they read the same thing, the different interpretations. So that's why you really want to be clear about that.
And that brings up the next question that I have for each of you. Give us a sense for specific industries where leases are particularly difficult or they have to be crafted in a particular way, and you as a litigator want to make sure that there are some specifics included. Because, for example, Adam mentioned like a liquor license, or if you're, selling a cannabis shop and the cannabis shop has to include a license. What industries are out there where you both, as a litigator, want to make sure that there's specific language included? This time, Adam, we're going to start with you, and we'll go to Alex after.
Well, the first thing that popped into my head, Dave, and it's a little bit of a twist on your question, is less the kind of industry, but more the kind of building. Especially if you are leasing in a co-op or condo context, there is an added layer of complexity in these leases, which I see all the time, where the landlord under the lease is either the commercial unit condominium owner or the long-term master commercial leaseholder of a co-op. And in those situations, it is very clear that the parties, it's very important that the parties make clear whose responsibility it is as between landlord and tenant to deal with the board. Because alterations, okay, sometimes they require board consent, sometimes they do not. The extent to which the board is involved and who's responsible for indemnifying the other for the costs and expenses in connection with the co-op or condominium's review is an area ripe for ambiguity due to that extra layer of complexity of ownership, which you see a lot in Manhattan retail.
I love it. That is a good one. Alex, to you.
I do a lot of net leases, which are leases for full buildings, where the net lessee is a non-profit operator. So for a lot of like homeless shelters, migrant shelters, things like that. And those leases require a lot of specific provisions as it relates to this specific government entity that provides funding for it and a lot of compliance for it. Those are very complicated. Also, if you look at a lot of restaurants have very specific provisions for the type of restaurant. Catering halls, if you need a public assembly permit, a liquor license, other types of permits that relate to that. The other thing that I've seen is very interesting are, to Adam's point, buildings that may be unique in terms of whether or not they are a historical landmark or not. But also there are a lot of buildings, for example, that have had special things in it. Our firm has had the privilege of representing a lot of landmark buildings in New York City, where inside those buildings they've had very unorthodox equipment in there, like Ferris wheels or ride attractions, things like that. So when you have that type of equipment, you would need different types of insurance, different types of provisions. And a lot of things that you see in that situation is, who gets custody of the Ferris wheel? Does it become a fixture in the space, or is it the property of the tenant? These are the things that come up on a deal-to-deal basis that you don't typically see.
All right, so Ferris wheels notwithstanding, let's talk now about some unique New York stuff. I mean, you work in New York long enough, you think you're going to see everything. Let's talk about the force majeure clause or unforeseen circumstances. You guys are litigators. How big is force majeure? Can you drive a truck through force majeure? I want each of you to tell me what your opinion is. How can we work on that? If I'm the landlord, how can we work on that force majeure clause so that it can't, it seems like every other day there's something going on in New York that could be an unforeseen circumstance. So talk about that clause and how much of a headache it is for you guys. Alex, start with you.
So force majeure was something that was really popular going back in the COVID pandemic. A lot of people tried to say that they couldn't perform under their contracts because it was impossible due to COVID and government orders and executive orders to shut down and operate. but essentially, the courts recognize whether or not they actually are able to, or if it's just a hindrance. Force majeure is essentially where the courts look at performance is impossible because if you can't even, for example, access the building and your contract provides that you are to deliver through this building, but there's no physical possible way to get in, that's force majeure. In COVID, the courts actually said that, for example, the COVID pandemic is not an event of force majeure because most force majeure clauses did not say, they typically say act of God or things rendering impossible, but the court said, well, it had to say of a pandemic or epidemic event. So now a lot of times tenants will try to negotiate in the leases that force majeure will be deemed a pandemic or epidemic event. It's not really agreed to very often. You don't see many people, if any at all, agreeing to that provision based on where the courts have relied previous. And this was kind of the same discussion that it was analogous to what happened in 2001 when the 9/11 terrorist attacks happened. In landlord-tenant leasing, a lot of people talked about force majeure in downtown Manhattan to comply with their lease, and the courts kind of applied a very similar, to the extent the buildings were still there, a very similar ruling.
Adam, what are your thoughts?
Yeah, I mean, a lot of my clients look at, the recurrence of a COVID-like incident or pandemic in the future is just to say, the government's going to get in the way, don't overdo it. Don't try to, put that in because if it does, we're just going to make the best of it and move on. But the real area in my career where I have litigated force majeure was dating back to Hurricane Sandy. That was 2012, I believe. That's where the coastline of New York City and Brooklyn really got decimated. We represented some very large institutions along the Hudson River that had its buildings rendered partially unusable, right? Some lease clauses, the standard form REBNY lease might have used the phrase wholly unusable instead of partially unusable. So that's one area where you may not want to rely on the form and really think ahead. I mean, nobody could anticipate the magnitude of that storm and what it did, to buildings, to cars, to fixtures, and really forced property owners to completely rethink not only could they use their existing buildings, but how are we going to protect against the next 100-year storm, which seems to happen every 5 years now or whatever it is. But to really think about, how do we engineer this to not have the next force majeure claim?
All right, so before we wrap up here, I want you guys to kind of look into your litigation crystal balls, and I want you to tell us what you think. Now, let's say you're standing in front of all the transactional lawyers at your firm, and you're gonna give them advice, and they're willing to accept your advice, that you can see what's coming down the road for them. What would you tell them they got to keep an eye out for? What's the one thing that, if it was your building and your lease, what's the one thing that you would say, you got to keep an eye out for this? Adam, we'll start with you.
I mean, you got to have a creditworthy guarantor. That's a major thing that I see a lot of landlords just to say, oh, it's not important because they're going to give me the keys back and I'm just going to move on. But if you're negotiating a lease, I'm not talking about the $4,000 a month corner deli lease or whatever in the outer boroughs. I'm talking about, real valuable leases with creditworthy tenants, bankruptcy filings, economic downturn. These things are real risks in today's economy, in uncertain times, and the landlord needs to have some teeth behind these. A lot of times leases are signed by single purpose entities, okay, rightfully so, because they want to limit their liability. That's where the guarantee comes into play. Is it going to be a well-financed individual? Is it going to be a publicly traded or well-funded parent corporation that's going to stand behind this? Is there going to be a substantial letter of credit? In lieu of that, what's your backstop? What's your backstop for all the time and money you're investing in this deal, tying up your property, paying your transaction and litigation counsel to look at this from all angles? This is your future, given whatever your financing terms are. Think about what is backstopping you from really putting your property in financial jeopardy.
I love it. Okay, thank you, Adam. Alex, to you.
First, I'd say call Adam and I to discuss. That's the first thing I'd say. The second thing, though, Adam actually hit it really right on the head. I was going to say, know who you're dealing with, know who you're getting in bed with, because I've seen too many times landlords and tenants will enter into leases with one another. From the landlord's perspective, they think they're entering into a lease with so-and-so has good assets, or that this is a sophisticated operator. And it turns out this is not the operator they thought. They really didn't do their due diligence. The person has no credentials. He has no experience in the space. Because landlords want tenants that add value to the building. You want to have, if you have a ground floor retail space, you want to have a flagship space or something that serves that community very well. You may not want, like a tchotchke store or something like that. And if you have a skyscraper on 57th Street, you're not really looking for one of those types of luggage stores or something like that. You want to make sure that you have a good operator, something high end, or something that will be good in that community, that will add value, because you always want to think about the next tenant. When that space opens up, you want to say, look, the tenant that was there before did very well. They did this in sales. They did this. Nobody wants to go into a building that the previous tenant, there was no foot traffic there ever. Nobody wanted to go in there, because reputation is everything. So really know who you're dealing with. And I would also say that Local Law 97 is probably something that's really important in leasing right now for the sustainability standards in the next few years, which is something that's evolving every single day, it seems, in terms of how it's being handled in modern practice. Those are the things I think our colleagues should look out for.
All right. So, Alex, since you brought it up, what's the best way for people to get a hold of you? Give them your phone number. We'll put your email and phone number in the show notes, but give them the phone number right now.
To reach me, you could email me at aestis@rosenbergestis.com, and my phone number is 212-551-1204. But also feel free to call my wonderful partner, Adam, who could be reached at
212-551-8405, Lindenbaum@rosenbergestis.com.
All right, gentlemen, we're going to put all of that information down in the show notes. This was a great show, and I remind everybody this was for entertainment purposes only, because these guys are entertaining. If you need legal advice, they just gave you the phone number and the email address. You can find all of this information down in the show notes and on the Rosenberg and Estis website. Rosenberg and Estis has been shaping New York skyline for over 50 years. My thanks to Alex Estes and Adam Lindenbaum of the Rosenberg and Estes Litigation Department for joining us today. We'll see you back here next time on another edition of Inside Rosenberg and Estes.
Thanks, Dave.
Thanks, Dave.
Thanks, Alex.